So welcome, Professor Ann Bartow, Professor of Law, University of New Hampshire. She is the director of the Franklin Pierce Center for Intellectual Property. And this is a top 10 IP law program in the US for nearly 30 years. And they're really at the forefront of developing developing IP infrastructure around the world. Professor Bartow is a graduate of Cornell University and University of Pennsylvania Law School. And she focuses on the intersection between IP and kind of major public policy concerns, privacy and technology law, and feminist legal theory. Obviously, it's impossible really to give a comprehensive account of all the amazing things you've done so far. But I think it is fair to say that you are the authority in the field of IP and feminism. So I feel privileged to have you here today. So thank you so much. Professor Bartow will talk about intellectual property and the feminist gaze. This is going to be an exciting talk ranging from gender fluidity in robots to cheerleaders' uniforms. And Professor Bartow will show how IP law policy and practice have been shaped by the so-called male gaze. So thank you very much for accepting our invitation, and the floor is yours.
Thank you so much, and thank you for that kind invitation. I actually stepped down as the director of the Franklin Pierce Center at the end of June, so that's why I look more relaxed. But we still have a great center. We have a great new director, and the program is going very strong. Thank you for the kind words about my law school, which does, I think, do a great job. But I am far from the authority on feminism and intellectual property. There are wonderful scholars. There's a lot of people, surprising amount, doing the work. Karis Craig at Osgood Hall of Law, Hall of Law, is that how they say it in Canada? Osgood, I always call it, is a phenomenal scholar. Rebecca Tushnet at Harvard has written some great stuff. I'm going to forget people, but if you want a bibliography or to learn about other people, I'd be happy to provide it, because there really is a lot of great stuff in the area, surprisingly so, in a good way. So I would call this presentation Copyright the Feminist Gaze, and I actually started off writing this because I wrote a book chapter. Irene Calbally at Texas A&M compiled a book, edited a book on methodologies, and so she asked me to write about feminist methodologies. So that got me sort of thinking about some of these issues, and that evolved into this presentation. And that chapter is, I believe it's at the printer right now if you're interested in the book. It's got methodologies from a lot of different critical legal theory perspectives, and I think it's going to be really good. So, okay, so first I call it the feminism, copyright law and the feminist gaze. And so the reason gaze comes into it is there's a woman named Laura Mulvey, who many of you may have actually heard of. And she's a feminist film theorist, and she was best known for her essay, Visual Pleasure in Narrative Cinema. And in it, she asserts gender power asymmetry is a controlling force in the cinema, constructed for the pleasure of the male viewer, which is deeply rooted in patriarchal ideologies and discourses, meaning the male viewer is the target audience. The women, however, are relegated to being the bearers of meaning, not the makers of meaning, the bearers of meaning. They're never permitted to take control of a scene, but they're usually there to be observed and to be objectified. And here's just an example. The male gaze theory holds that women in visual media are viewed through the eyes of heterosexual men and represented as passive objects of male desire. Audiences are forced to view women from the point of view of a heterosexual man, even if they are heterosexual women or homosexual men. This affects how men look at women, how women look at themselves, and also, fairly importantly, how women look at other women. And so the picture's just from a film, and you can see the women are in bikinis, and the guy gets to wear like clothes, and he wears baggy clothes, nothing body conscious. And he's, standing there kind of in control, where the facial expressions and the postures of the women in the picture, and this is a mainstream film, very different, right? So I think that picture encapsulates exactly the male gaze kind of in action. So I want to call it what I call the feminist gaze, is what I brought to the theory, the methodologies, the study that I did, which is you look into the roles that women play in a particular context, and then how they are affected by the processes and outcomes, which is just a really different way of saying, how women look at men look at women, etc., and everybody looks at each other. So the feminist gaze just puts a spotlight on women. Okay. So another person who's written about this that I'm sure is familiar to you, Simone de Beauvoir and the Second Sex. And she wrote that men fundamentally oppress women by characterizing them on every level as the other, that they are defined exclusively in opposition to men, that men are the self or the subject, and women is the object or the other. He's essential, absolute, and transcendent. She is inessential, incomplete, and mutilated. He extends out into the world to impose his will on it. Women are doomed to immanence or inwardness. He creates, acts, and inverts. She waits for him to save her. Again, these are roles that people are forced into, and then roles that the media, as Laurie Mulvey said, play out into the media. So Beauvoir identifies the economic underpinnings of female subordination and the economic roots of women's liberation. She says only in work can women achieve autonomy, but if a woman can support herself, she achieves a form of liberation. And then in the concluding chapters of The Second Sex, she talks about the logistical hurdles that women face in pursuing this goal. If you want to look at, so actually go back, yeah, her famous quote is, "One's not born a woman, but becomes a woman." And basic feminist legal theory, if you want to apply the feminist gaze to basically any discipline in law, you can start without having any real background in just noticing disparities and literally counting bodies, theorizing differences, ascertaining impacts, and explaining how to address and fix inequities, which starts with just noticing disparities. I was a co-author on an article in law school because for whatever reason, strangely enough, I seemed to be the first person, including staff and faculty, the first person in my law school to notice that women were getting much lower grades than men. And I didn't see their grades. Everyone's grades are confidential, but what I did see at graduation, because I worked, when I was a first year, second year, I worked at graduations. And when I graduated, you get a program. So you get a program at graduation, and it tells you who got, awards based on GPA, who made the law review, everything, almost all the awards in law school at the end of the 3 years terms when you graduate is based on grades. And guess what? The men were sweeping the awards. So I noticed that for when I was a second year, I looked back and I found the program from the first year. It turned out our library kept track of, they had the graduation programs going back many, many years. So all I had to sit down in the library was sit down, look at the names, and then I had to make judgment calls. Of course, there's always going to be a few things off because of the J.K. Rowling syndrome, right? Which is that women will sometimes use initials to hide the fact that they are women because they think they will sell better if the people are ambiguous, if their gender is ambiguous. And then I had to make guesses based on first names, which are, sometimes not I don't perfectly know which are female names or male names, but I still think I got a pretty good idea. And then when I graduated law school, the same thing. Open the program, it was like men, 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 men. So ultimately an article and then a book was written about that called Becoming Gentlemen. So that's when I sort of became the feminist legal scholar, although it took a while before I became a professor after that. So these are just things that you can do. It's a basic feminist legal theory, and then you just apply it to intellectual property law. And I just give a non-IP law example, which is the Lilly Ledbetter Fair Pay Act of, that's a typo, should be of and not off, 2009, following loss at the US Supreme Court. So basically, Lilly Ledbetter was a woman who's getting paid significantly less than the men she was working with. She had more experience, more seniority, and got better evaluations, but she was still being paid less. And when she figured it out, after it had been happening for many years, she sued, and then the lower courts and ultimately the Supreme Court said, well, it looks like a problem, but you're too late. I just said that, some statute of limitations theory that it was she needed to sue when it started happening, not when she found out, which of course, the minute she found out, she sued, but they told her too late. This has been happening for years. It's your own fault for not figuring out. You're out of luck. So that's what the Supreme Court did. Ruth Bader Ginsburg, the late justice who we just lost, was a very feisty dissent about that, which we all appreciated. And then once Obama took office in 2008, and he had control, at least for the first 2 years of the Senate and the House, they were able to pass the Lilly Ledbetter Fair Pay Act of 2009. That was, in fact, the first bill that Obama signed into law in 2009, the very first one. So that's just an example of people watching, right? And Lilly Ledbetter figured out ultimately that she was getting paid less, and then started following the thread. And it turned out a lot of people were in that situation. When the courts couldn't help, then Congress stepped in and was very helpful. Okay, so now moving back to intellectual property, women are underrepresented in every area of intellectual property, it turns out. And just to start, even though my focus will be copyright, to start out with patent law. So in patent law, there's actually a fair amount of empirical work that has on gender and some other, some race, some other things, although gender tends to be a little easier because you can make make guesses on people's names. The Patent Office of the U.S. Patent Office does not collect gender data on applicants. So they do not ask inventors when they're filing patent applications what their gender is. They could. Should they is actually kind of a tricky question, as it turns out, and I'll address that in a second. But in any event, patent law, there are fewer women than men who are inventors. There are fewer women than men who are patent agents or patent lawyers, fewer women than men who are patent examiners working at the PTO, or patent litigators working at a law firm, or district court judges who hear patent cases, or federal circuit judges who hear patent cases, and of course the Supreme Court, the same thing. Fewer women, however, who apply for patents are successful. So this is a reason why it might not be a good idea for women to signal their gender on a patent application. As much as I would like the data that comes from women, the data collection that would come from people's patent applications, if they did signify gender, race, maybe some other stuff, it would be great to have that data. It would be stronger data than one can collect based on, secondhand. But at the same time, if the patent examiner knows you're a woman, or any other things that would appeal to potential bigotry, that could be a problem, because already women who apply for patents are less successful. Now, is there intentional discrimination based on gender? I doubt it, at least most of the time, but implicit bias, right? The idea that maybe if somebody's name is Julie, that maybe we are a little more suspicious about her scientific credentials than if her name is like Warren, something manly, where you picture a person in the laboratory. So fewer women who apply for patents are successful. When they are rejected, women are 2.5% less likely to appeal. Now, it may be their choice or it may not. These are the named inventors. It may be their companies or rights holders, licensees who make this decision. But for whatever reason, not only do women succeed less frequently, but they also are taken on appeal. They appeal for whatever reason, either their choice or someone else's, less likely to appeal. So when applications were granted, oddly enough, women's patents had more words added. And when more words are added to patent claims, that actually reduces the scope of patents, because you start out with your claims, which is, what you're explaining what you own, and more words are usually qualifiers. So actually, when more words are added, the scope is reduced, meaning the patent is less valuable. So women's patents, even when they do issue, get more changes at the PTO, and therefore usually that's reducing the scope of their patents. So even if approved patents fare poorly, women's patents are maintained less often by their assignees. In other words, sort of the rent, right, the fees to keep your patent going. And they tend to receive fewer citations from other inventors and from patent examiners. So kind of a gloomy picture on patents for women generally. Also patent law, women inventors account for just 13% of patent applications globally, and it's about the same in the United States. I don't know what it is in the UK, but I'd be interested to learn. The gender disparity among inventors is even starker if you take into account the fact that most female inventorship takes the form of a lone female on a male-dominated team. So that patent with one woman inventor gets checked as credited as having a woman involved, but usually that woman will be outnumbered by men. So it's not really a woman's patent, depending, I guess, on how you want to define that. Women have trouble raising money to patent and commercialize their inventions. Companies founded solely by women got just 2.2% of venture capital funding in 2017. And a lot of times women's roles in research is invisible. Acknowledged programmers or researchers whose names don't appear on the top of a final paper, but they came up with the programs, are more overwhelmingly likely to be women. And of course, Rosalind Franklin, infamously, or famously, I guess, she was pretty famous as she should have been, but not as famous as she should have been, since her research was stolen by Watson and Crick, the DNA story. Okay, moving into copyright law. So copyright law, women are underrepresented in most creative fields. Even in disciplines where there are appreciable numbers of women in the pipeline, the authors who have the most commercial and critical success are overwhelmingly male. And you can break this down in any area you want. Like if you just even if you look into book publishing, or if you dial it down into novels, who's publishing novels, you'll see that women are actually publishing novels at higher rates than men in some categories and overall, but it's male novels that tend to sell more, and they tend to dominate the bestseller list more. So you could dial it down to something as specific as like murder mystery novels and see how it's gendered, or look, broad scale at book publishing, and including everything like textbooks, any kind of book, and you'll always see men coming to the top. Now, in science and patent, we say, oh, it's a pipeline problem, although that's an easy explanation. I think sometimes it shuts off discussion. But even in copyright, we see this issues. And actually, the pipeline, there's no pipeline problem. So actually, I'm teaching art law this semester, which is a really fun course to teach. And one of the things in art law you can't help noticing is that men rise to the top. Like the paintings that are going for millions and hundreds of millions of dollars are all painted by men. Women are underrepresented in every field of the visual arts, in museums and galleries. But there is the opposite of a pipeline problem. In this visual arts, like studio art, the overwhelming number in the United States of studio art majors are women. Art schools are flooded with women, and yet the people who rise to the top are the men. So there's no pipeline problem whatsoever. It's like sheer sexism that's going on because there's no pipeline issue whatsoever there. And then, sort of as a corollary to that, when boys are dominating STEMs, everyone's like, oh, we have to get some women in, and so there's some programming, we just get women into the STEM fields. When women are dominating art schools, nobody says, oh, we don't have enough boys in art, let's make special programs to recruit boys to art. That never happens. Is art as valuable as science? That's a complicated debate, but what's clear is anything that's dominated by women is not seen as something attractive to move boys into. So that's in the United States. I'd be interested in other nations, what that data looks like. So basically, whether one considers patentable inventions or copyrightable works, the rights to the vast majority of programs to attract girls to schools that are specialized in math and science. Boys continue to outnumber girls by a wide margin, but when they concentrate on music, fine arts, dance, and theater, there are no programs to attract boys, even though women outnumber the boys at art schools by an even greater number than the STEM disparities. So, copyright. There are negative spaces in which we really don't have official copyright in the United States, although there are some moves in those directions. But the traditional spheres of creativity that women dominate are the ones that are ineligible for copyright or have the weakest claim to copyright. For example, cooking. Recipes can be copyrighted in like a cookbook can be copyrighted because it's a book, but the recipes themselves have been held so far uncopyrightable. There's actually a movement in the United States to try to bring copyright to food plating, which I think is a terrible idea, and I'm actually working on an article about that right now. But by and large, cooking is not protectable by intellectual property. Makeup application, people can do amazing things with makeup application, just sprucing up your face to go out to, for movies and cinema, for theater. Makeup, I think, can be an art, but it's not something that's been protected by intellectual property. Don't get me wrong, I don't think it should be, but I think it's interesting that the women-affiliated arts are the ones that don't get the copyright protection. Hairstyles, clothing, of course, I'm going to talk in a minute about the Varsity Brands case, but by and large, clothing has so far not been copyrightable for the most part, other than fabrics. Quilting, gardens, the only cases we have on gardens in the US say that flower gardens are not copyrightable. And then interior design. So these are all areas where there's a lot of creativity. There's not a lot of intellectual property. I tend to favor low barriers in intellectual property, so I'm kind of glad about that. But on the other hand, all the money that gets made commoditizing creative works goes into other works that tend to be dominated by men, where the women could dominate. These are the ones where we say no intellectual property for you. Okay, so this is the case Star Athletica versus Varsity Brands. So this is a case in which one company, there's really a couple of companies dominating cheerleading uniforms. And I don't know what it's like in other countries, but in the United States, cheerleading is like a big deal, and it's present in ways you might not be aware of if you don't have this in your home country. So we have professional cheerleaders at professional sporting events. Football, basketball, etc., though not every team, but a lot of teams do. And then college sports, which is a big thing in the United States, nonsensically if you ask me, but the sports in college have this relationship, and most of the money sports are all men. All the players are men. The coaches are almost all men. But the women, if they get a role at all in like college football or college basketball, is usually cheerleading, right, to rev up the crowd. So a lot of college people and a lot of have the role. It starts in high school. So high school sports, the male sports often have cheerleaders. Again, the sports like football, men's football, men's basketball, they tend to have women women cheerleaders. And then there's little kid cheerleading, which is a sport, and it's basically synchronized gymnastics. But little kids do this, mostly little girls, and their parents buy uniforms for them. And they buy a lot of uniforms, because if you start when you're 5 years old, probably every year you need a bigger uniform if you're going to continue cheerleading with special sneakers, so all the kids have the same uniform. So basically there's a lot of money in cheerleader uniforms, much more than you would think. And Varsity Brands went ahead and copyrighted some of their cheerleading designs, and basically Star Athletica was in a position where they were not going to be able to compete because the Varsity Brands had copyrighted some of the features of the uniforms that were popular. And so if one person can copyright the popular uniforms, then the competitor is kind of can't compete because they can't produce the popular things on the uniforms. So you can understand that if it's a really complicated design, but in fact, in this case, the uniforms were just very, very simple, that the Varsity Brands managed to copyright basic things like chevrons, zigzags, and stripes, just simple symmetrical flourishes that appear and have since the beginning of time on cheerleader uniforms. It got before the Supreme Court in an outcome that's heavily criticized. You've already noticed by me, but by almost anyone who reads it, the justices, for whatever reason, voted 6-2 in favor of a certain interpretation of the Copyright Act, which said very simple ornamentation of cheerleader uniforms would be copyrightable. So Varsity Brands basically is going to shut down Star Athletica, and then they can jack up their prices because they're effectively monopolizing the market for cheerwear with basic, things like stripes and zigzags, chevrons. This is, classic cheerleading uniform since I was a child, not a cheerleader though, but since I was a child and was around cheerleaders, and basically 5 styles are what people are buying now. So here are the visuals on this. The ones on the top, the uniforms across, these are the ones. They're the 5 designs that Varsity Brands copyrighted. So you can see they're kind of alike, and they're a certain kind of design, and then there's a picture of a woman in one of those, a live woman. And so these 5 designs, they're all for women. They did not copyright any of the cheerleading designs for men, and they do have uniforms for men, and the men do cheerlead, right? So they're the ones who throw the women up in the air for sort of the gymnastics part of it. So these are the 5 designs dominating Varsity Brands' costume portfolio. And all they do is, these are the basic 5 kind of costumes they offer, and then when when a school phones in, then they alter the colors. In other words, every school has school colors, and so that's how the color choice is made. So I point that out because Varsity Brands is not choosing the colors, their customer is choosing the colors, and the customer is choosing which kind of design features they want, and then the uniform usually gets embellished with the school's name and logo. And then the copyright designs, however, in the United States and in many places, you cannot copyright something that's functional. So to reach their decision, 7 of the US justices decided that these cheerleading uniform, the design attributes, were non-functional. In fact, if you've lived, if you've ever been a cheerleader or thought about, clothing or design, lived a life of even wearing clothes, no less cheerleading uniforms, you know that there are design attributes that will make you look a certain way. Like all of us of a certain age and size know, no horizontal stripes, or black is slimming, like sort of the basic precepts of fashion. But if you have if you're a cheerleader where the whole goal, part of the cheerleading uniform is to show off your body, then in fact you appreciate the fact that the copyrighted designs by Varsity Brands were intended to make the wearer's body look attractive in a very sexualized way. So if you look at the way the chevrons are in the designs, you can see they're meant to accentuate the breasts of the wearer. And then at the center, where over the stripes or the X's are, and also below the chevron, those are classic designs to make the person's waist look smaller. So the cheerleader uniforms are designed functionally. You can see how they're sleeveless. They're designed functionally so the cheerleader can move around, because moving is important to cheerleading. But you see how short the skirt is, and then you see the way it's designed. The entire intention of the uniform is to make the cheerleader's body look good in a sexualized way. There's nothing wrong with looking good in a sexualized way, but let's not pretend there's not a functional thing happening here. It's not accidental. She just happens to look good in the uniform. The uniform was designed so she would look good in the uniform, and now Varsity varsity brands can monopolize that. And so what I understand, and I'm going to be very sexist here, I understand why the male justices may not have gotten it, because men tend to dress just not naturally, unnaturally, but societally, men tend to dress a lot different than women. There are certainly a lot of exceptions, but men tend to wear baggier clothes, and women get kind of pressured to wear more body-conscious clothes, and that plays out, I think, almost to an extreme manner with cheerleader uniforms. So here are some examples. You can see the women and the men. At the top, this is the University of South Carolina cheerleaders on the top, and then a Michigan cheerleader on the bottom. And so while the company sells and designs uniforms for boys and men, it's just women, the girls and women ones that were subject to dispute, because let's look at the ones for men, right? The ones for men are t-shirts and shorts or long pants in school colors. They are baggy. Look at the male cheerleaders. They have a baggy t-shirt. They have baggy pants on. That's almost all the male uniforms. Now, these men are in very good shape, right? They probably are very attractive. They probably have nice abs or whatever. I'm not speculating to go too far down that direction. But my point is, if we want to see the women's bodies, and that's why we give them short skirts and body-conscious clothes, why not the men, right? There's certainly people in the audience who would like to see attractive men's bodies, I have to guess. And that's not facilitated, right? So the men, because this is hot too, in South Carolina in the summer when you're cheerleading for football, it's hot and humid weather. The men at least get baggy clothes, and often they get shorts. They have pants on here, but the women, you know, it's all very body conscious, and you can see they're trying to accentuate the lines. The South Carolina ones have those, I don't know what they're called. I'm not big on fashion, but those things down the side are meant to accentuate your waist and make you look slimmer when you have those side panels. And again, nobody cares if the men's look slim. They're just supposed to be comfortable. It's like a whole different aesthetic for them. Segueing briefly into trademark law, women are objectified in trademarks, advertising, and branding. Racially offensive trademarks are challenged, have been challenged in the United States, and it was ultimately unsuccessful in cases, the first case with the Harjo case, and then the Tam case under Section 2 of the Lanham Act, comprises of immoral, deceptive, or scandalous matter to disparage or falsely suggest, blah, blah, blah. That's Section 2 of our Lanham Act, our Trademark Act. But when racially offensive trademarks were out there, they were challenged. Now, they lost because of our First Amendment and other reasons, so I don't want to paint a rosy picture, but there were people out there willing to put the time and the money into challenging this practice that has never seriously happened for women. In other words, there's been more of a cohesive community objecting to racially offensive trademarks. Part of that community certainly women, but there has been no serious sort of community of women that's risen up in any way to litigate under that provision trademarks that were sexually offensive. So that part is, that section of the Lanham Act is pretty much dead. Some of it still survives, so it's not completely out, but basically your ability to challenge a mark being deceptive, scandalous, etc. is gone, because in addition to the Tam case, there was also the Brunetti case, which involved, excuse me, this, I was going to say it involved the word fuck and whether you could trademark the word fuck, and it turns out you can. So anyway, that's am I okay for time? I hope so. You just let me know if I'm running over time. Okay. You're right. All right. So in addition to trademark law, in addition to straight up trademark law, there's stuff that I call trademark adjacent. And that has to do with naming rights and like statues in the public and the physical public domain. And here again, we see women are grossly unrepresentative. So sometimes naming rights are purchased directly as a sponsorship. That way you could get your own name or your company's name or your father's name or whoever's name you want on a building or on a classroom or on a public square. So that's purchasing naming rights directly. Sometimes it's purchased indirectly as a reward for a gift. So universities like to position themselves as less money grabbing, so they won't let people just buy sponsorship rights usually. But what they will do is say, well, if you gave us $10 million for this, you know, toward this new stadium, we'll name the locker rooms after you, or you know, something along those lines. So there are really rewards for gifts that are basically purchasing naming rights. And sometimes just male politicians get their names on stuff, that male-dominated political processes, that when they have political naming gestures, they tend to be men. So women are just grossly underrepresented on buildings, streets, parks, stadiums, law schools. There's the Sandra Day O'Connor Law School in Arizona, and there's the Elizabeth Howard Law School, which is Pace Law School in New York. But other than those two, there are a lot of law schools that are named. So those are the only two named after women. All the rest are named after men if they're named after a person. Currently in the United States, memorials to the Confederacy are being challenged as part of the public domain, a little bit affiliated with the Black Lives Matter movement, but there are a lack of memorials to women, and that's being addressed more slowly and less dramatically. So right now, statues of the Confederacy are being torn down, but in the public conversation about how, if we're going to replace them, how to replace them, I would hope that the very few number of memorials to women are addressed, but it is, and there are people that are looking into it, but not too many. So this is trademark adjacent rights, but I wanted to mention them here because they overlap with architectural, pictorial, graphic, and sculptural works. In other words, if we're going to have more memorials to women, they will be copyrighted, and that's kind of important for a bunch of reasons. One is, who's going to be commissioned? Are they going to commission men to make these missing memorials to women, or are women going to be commissioned to make the missing memorials to women, the ones that don't exist? So there's a lot about copyright that will actually affect some of these choices. Okay, so then as in addition to pictorial, graphic, and sculptural rights overlapping with trademark and naming rights in the physical public domain, of course, we know that artificial intelligence and robotics are hugely intertwined with copyright law, right? We know in the United States, copyright software is copyrightable. We don't have any sui generis protection. Copyright law tends to be a bad fit with computer software. Visionaries like Pam Samuelson pointed out at the beginning of the computer age that this was a bad idea. Nonetheless, copyright is what the US uses, and that's all they have. So when you look at AI and robotics, there's necessarily a lot of copyright law going on, and there's also a lot of gender things going on. So a few observations about artificial intelligence and robotics. First is that people find robots with human characteristics more reassuring. Animals sometimes too, but human characteristics are definitely the most reassuring for people. Robots do not need a gender, right? They just don't. They're not going to reproduce organically. So we need a factory to reproduce them. So they don't need a gender as a functional matter, but it turns out that just like in humans, androgyny makes some people very, very uncomfortable. So most robots do tend to be gendered for their clientele's comfort. There's also gender policing of robots, that there are gender norms enforced with respect to the appearance, names, design, and function of robots that parallel this kind of things that are enforced with women, right? With women. So gender designation affects, so when you look at people and how this plays out, gender designation affects the perception of robots. The two identical robots, one given male characteristics, will be perceived as smarter with the same personalities. The female robots will be perceived as more caring. And of course, they will also be sanctioned deeply if they're not, right? If the male robot isn't perceived as smart, or the female robot is not perceived as more caring, they may be seen as faulty robots because they're not performing their gender appropriately. Male robots in this culture are largely associated with soldiers, war machines, drones, weapons, and cars. So soldiers, there are plenty of women soldiers, and drones, why they would be male, or weapons, why they're male. It has to do with society. And then cars, which, really women do a lot of carrying in cars, but somehow the cars themselves get to be male. So male is associated with all these things. Do you want a male robot? Maybe you want a male robot if you want to defend yourself against danger, but do you want a robot in your home that could strangle or electrocute you in your sleep, right? That's a real concern. If the robot's a soldier, that something goes wrong, if they're primed to kill and defend, one wrong move, right? One wrong chip or something, or one wrong 0 and 1, and you could be in danger from that robot that's in your house, okay? Alternatively, female robots are associated with caretaking, kitchen appliances, child-related accessories, bouncy chairs, cleaning equipment, and they also are the voice of helpful assistants. So Siri, Alexa, and the Google smart speaker, and most channels of GPS all have female voices.
Sorry, I'm not sure about
Oops.
that.
I have a Amazon thing that just heard me say Alexa. Sorry about that. That was kind of weird. I should have thought of that. In any event, helper voices, right? People are going to assist you or help you tend to be female, and that's because female voices are preferred based on societal expectations. However, will your Roomba back you up in a fight with an intruder? All right, and Roomba's going to get your floor nice and clean, but it will not have the deterrent effect, perhaps, that the male warlike robot would have for defending you against an intruder. So then we come to robots as sex partners. That's the maybe this topic you didn't expect to come up. But in fact, there's a lot of gendered stuff that goes on with this. And I'm sorry to say it, but as soon as robots with humanoid features started coming on the scene, like the 1960s or whatever, when people were thinking about robots, one of the first things a group of people thought is, wow, let's have sex with them. Let's have sex with robots. So sex robots have been a thing since literally the 1960s. Sex robots tend to be designed strictly for human pleasure because they are completely controllable sex partners. They can perform in ways that humans cannot. There are no consent issues with a robot. Robots can have fake autonomy in bed if that's what the controlling human wants. Isn't that ironic? You can control somebody and force it to act autonomous in bed. So if people have enough control over the robots, this fake autonomy can be built in. And there's a sexual continuum. So robots can be programmed from wild to frigid, with frigid designed for rape role playing. So then there's a question, can you actually rape a robot? Probably only if it belongs to somebody else under a current system, and even then only amendments to rape laws, something I don't spend a lot of time thinking about because it's so terrifying, but it really is something to think about. Why do so many people want a sex robot that can be programmed to frigid, right? I mean, that's usually not seen as a good thing. So then the really, I think, difficult questions are, what are the effects upon human-on-human sex? That if people are used to having sex with robots, will that change consent norms? Will it change expectations? Will it be similar to pornography in the fact that it actually desexualizes people? People who use a lot of pornography tend to have less sex and want to have less sex with actual humans. Maybe the robots have the same effect. Would it be an outlet for culturally legally deviant sexual acts? Would it be helpful, for example, to pedophiles if they had robot outlets and that made it, easier for them to leave real children alone? These are all a lot of complicated questions that really need answering. So then I ask a question then, would it be good to have gender fluidity in robots? If we had robots that could routinely switch gender identity or performance, would they be more acceptable to humans? Would a robot that first, defended you against an intruder and then actually cleaned your floors or took care of your child and wasn't so scary as a war machine, would that kind of robot be more acceptable to humans and therefore more useful? And that's really an interesting question, I think, to think about, why it is that a machine that's going to do our bidding, that so many gender questions would be there, and then we'd have to kind of think through. But there's certainly an argument that a gender fluid robot would have more acceptance and applications. So that's it. That's the end of my formal presentation, but I'm happy to see what kind of questions you have for me and what conversation we can have.
Thank you very much. That was brilliant. I'm going to stop recording now so that people can ask questions and